First of all, just want to welcome everyone. And if we haven't met before, my name is Shannon, and I'm part of the Community Engagement and Events team at Russell Alexander Collaborative Family Lawyers. We want to thank all of you very much for joining us today for Family Law Now Live's presentation on Divorce and Property Sharing 201, Advanced Equalization Topics. This presentation is an extension of part one of this series that we hosted in May earlier this year, and we'll be happy to include the recording of that presentation in our follow-up email that will be going out tomorrow with our show notes. I'm going to start with a bit of housekeeping and introductions, and I'll let you know what's on the agenda for today before I hand things over to our panelists. And as we are presenting virtually today, we do apologize in advance for any technical issues that may come up. Once I pass things over to our presenters, I'll be available behind the scenes for any questions or tech issues. So if you are having any challenges throughout the webinar, you can contact me at shannon@russellalexander.com, and I'll do my best to help resolve the issue. You'll notice that the chat has been disabled on your end, and this is just to keep everyone's identities anonymous to other audience members. But as I mentioned, you can send in any comments or questions either to my email or through the Q&A. So in this 1 hour presentation, Russell, Nafisa, and Carolyn will be discussing advanced topics in divorce and property sharing, and they'll be covering the following topics. How do you calculate family property? How do you deal with the matrimonial home? How can you protect your inheritance from your spouse? Family trusts, equalizing pensions, defined benefit and defined contribution, cryptocurrency, tax and other considerations, notional disposition costs and capital gains, experts and business valuations, when an unequal division is appropriate, and supersized CP teams, corporate tax, legacy, and estate planning.
We'll also get through all that in an hour. Come on.
You guys are pros. We always manage somehow.
All right.
Do our best. And just want to mention again, for those who logged on recently, that there will be a Q&A portion at the end of the webinar. So if you haven't already, please feel free to submit your questions through the Q&A, and we'll do our best to get to it during at the end of the presentation or throughout. We also just ask that you please keep in mind that the content of this webinar is to provide you with general information and is not to be considered as legal advice. And we'll be providing links to additional resources mentioned throughout the event today in a follow-up email tomorrow, so keep an eye out for that. And without further ado, it's my pleasure to introduce today's hosts. We have Carolyn Warner, Nafisa Nazarali, and Russell Alexander. So Carolyn is a fully trained collaborative family lawyer who has a knack for developing creative resolutions unique to each client's situation. Carolyn has been practicing family law exclusively for over 8 years since her call to the bar in 2011. She is committed to providing her clients with empathy and sound advice, and prides herself on approaching all cases with an analytical and tenacious mindset. Nafisa is the senior managing associate lawyer at our firm, and she is a collaboratively trained lawyer and has been practicing exclusively in all areas of family law for over 10 years, with the best interests of children as a primary focus when providing legal advice and strategies for clients. She uses her skills as a collaborative lawyer to find creative ways of achieving positive results for her clients. And Nafisa is also committed to giving back to the community and currently sits as a board of director at Luke's Place, the Malvern Family Resource Center, the Durham Regional Law Association, and Collaborative Practice Durham Region. Russell is the founder and senior partner of Russell Alexander Collaborative Family Lawyers, and with over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. So now that you know a little bit more about our team, I'm going to pass things over to Russell to get started.
All right. Thank you for those kind words. Do you have a bit of a teaser here with the book?
Yeah, so we have an ebook that just, this is an advanced copy of our ebook on divorce and property sharing 101. So this is from our presentation, as I mentioned, that we had in May. So for those who attend and provide feedback with the survey and a suggestion for a topic, we'll be offering a complimentary copy to you.
So how can you go wrong, right? That's better than a free money back guarantee because you get the book.
Exactly.
Okay. Let's run a poll. So we're going to be doing polls throughout. Please provide us with your input. It's going to help us understand our audience. Also, please send in your questions, as Shannon indicated, through the chat feature so we can answer all the questions that come in, or as many as we can. So what's your reason for joining us today? So we're going to give you a few moments to answer this. And let's put up our next slide, Shannon, while this poll is open, if you don't mind. So divorce and property sharing 101. So this is what we covered off in our first hour that we've talked about sharing property, the basics, calculating property, the home, special considerations, the onus, equalization, and the limitation periods. Those are all going to be in our book, the book for the divorce and property sharing 101 that Shannon just mentioned. So we're assuming you have a basic knowledge. Today's program's designed to provide some more advanced discussion about some of these issues and some new issues as you've seen on the agenda. So let's see what our poll results are. See where our audience is coming from. So a legal professional interested in learning more, 76%. Another professional, 9%. Currently going through a divorce, 11%. Helping a loved one, 2%, and other, 2%. You can put that in the chat box. So thank you everyone for participating. We love the polls, but let's make a start. How do you calculate family property? I think, are you going to start this one off, Carolyn?
Start us off. Thank you, Russ.
Okay. Thank you.
We got a lot to go through. Let's do it. So when we're looking at calculating net family property, just a brief summary if you didn't attend 101, is we're really trying to establish how much money each spouse is supposed to walk away with at the end of the marriage or relationship, which is according to, we call it the equalization of net family property. So the formula that's set out for this is set out in the Family Law Act, and it's just the calculations of looking at each party's asset position, both on the date of marriage and on the date of separation. So the first step really is to calculate each party's net asset position on the date of separation. When we're doing that, we look at subtracting any legally permitted exclusions. So exclusions could be something like an inheritance, it could be something like a gift, or it could be something else that like the parties have agreed to be excluded. Sometimes it may have been outlined in a marriage contract or a prenuptial agreement. And then after that, we look at each party's net worth on the date of marriage. We're looking at the net worth, what they came into the marriage, what they had when they got married, and then we subtract it from their net worth on the date of separation. The whole purpose of this is to find out, if one party has a higher net worth than the other person on that date of when we're doing the calculation. And the view is that, the person that has the higher net worth would pay the person with the lower net worth so that they are paying 1/2 of the difference between their respective family properties so that they are essentially equal. This is the very basic formula. As we'll go through today's presentation, you'll see that there's some parameters where they don't just do an equal division.
Great introduction. Let's go to our second poll. And how many matrimonial homes can you own? And we're going to give everybody a moment to consider this question and put their answers in. And we have a question that came in from an audience member. Can property be equalized or resolved after a divorce? I think we've covered that one. So during our introduction, what happens if the limitation period to divide property is passed? What do we do, Nafisa?
Well, there is an argument you can make to try to set aside sort of a limitation period, and there is a test that's involved in that. So what a court would really look at, what's the reason for the delay? Is there a tolling agreement, for example? And based on that, you could actually get an order for an extension of time. So that's something that you can do if your limitation period has passed. There is a way. It is a high threshold, a high test, but there is a way to try to extend it.
The court's going to want you to explain the delay, right? If you're negotiating in good faith and it just happened to pass and you're still working out a deal, that's one thing. If you've sat on your claim for 15 years and never pursue it and knew about it, that's a totally different situation. So the facts are probably going to drive the answer to that question. Thank you. All right, let's see what our audience thinks about matrimonial homes. 34%, you can only have one. 14% said two, maximum of three. Unspecified, 50%. Pretty sophisticated audience here. I think unspecified is the correct answer. Do you guys agree?
Yes, it is.
Well, let's get into matrimonial home. That's going to be our next subject. It's a good lead-in. So I think you've got this one, Nafisa.
Yeah, so I have this. So in terms of the matrimonial home, when you think of the matrimonial home, you really need to focus in on what is the definition of this property. So the matrimonial home definition is found in Section 18 of the Family Law Act. And essentially what it says is that a matrimonial home is every property in which a person has an interest, and that is if the spouses have separated, was at the time of separation ordinarily occupied by the person and his or her spouse as their family residence. So what I'd like to kind of focus in on is the at the time of separation, because a lot of clients think that, you know, it's every residence that they ordinarily occupied during the course of the relationship, but it's really the last one that you were residing in together upon separation. This is an important distinction because at that particular definition, you could actually have a date of marriage deduction of a home if you've sold it during the marriage. So let's say you have a matrimonial home, you get married, you live in that home, you know, for the first 5 years of your marriage. Year 6, you decide to go somewhere else and you sell it. And there's one person, either the husband or the wife, that's on title to that property. You move into another property. Now you jointly own this property. The person who at the date of separation owned that original house can get a huge date of marriage deduction on that home because it's no longer considered a matrimonial home. So that's something that I think is really important to note. When you look at Section 18 of the Family Law Act, there's also other relevant considerations to a matrimonial home. So, for example, there's part of the section talks about ownership of shares. So if you own a share or an interest in a share of a corporation that entitles the owner to occupy a housing unit owned by the corporation, and this is deemed an interest. This is interesting because it's a situation where, you know, there's a husband or wife, they basically they have a corporation as an alter ego for their home. This in an effort to defeat the other spouse's claim, this protects against that. And then again, with the definition, there's a particular part that talks about residence in farmland. So, for example, if you have a property, and as part of that property you have a matrimonial home, it's only the property that's normally used for the purpose of that's other than a residential home. That's not considered a matrimonial home. So you would only be looking at, you know, the physical property, for example, if it's a farmland, because all the other areas, if it's used for commercial reasons, you could actually, you don't necessarily have to put that in as a matrimonial home. The other aspect I want to talk about, there's a lot to cover here, is just in terms of the equal rights to possession of a matrimonial home. Just this morning, a team member asked me, you know, can my client exclude her spouse from the home because she's the only one on title? And again, this is a question I get posed a lot. I refer the lawyer to Section 19 of the Family Law Act, because you cannot lock another spouse out of the matrimonial home, even though you're the only one on title. There is no right to sort of possession of the home. You would need to go to court and either you need to obtain an order for exclusive possession, or that spouse would need to voluntarily leave, but you don't have a right to exclude that person. So yeah, that's what I wanted to cover for this topic.
There's a lot to unpack there. Thank you for that, Nafisa. And when we get to inheritances and excluded properties, we're going to talk a little bit about cottages, because they can be matrimonial homes too, right?
That's right.
All right. So here we go. Our family cottage is passed down from generation to generation, excluded as an inheritance. This is a question we get all the time. Family cottages carry huge emotional attachment to them, right? Especially when generations have been going to that cottage. So we're going to get everybody a chance to answer this question, but let's go back to our audience questions. We've got some great questions coming through the chat box, the Q&A box. Here's one. In common law relationships that are clearly marriages, why does equalization seem so difficult? Is this not punitive and difficult? Why can we not simply call it equalization when a relationship satisfies the definition of marriage? So this came in advance. Nafisa and I were talking about it. Well, you're not married because you're not married, first of all, right? The Family Law Act has a specific section dealing with married couples. And so it's not quite as clear cut as this question makes it seem, but the common law, through judges and case law, are giving common law couples much more property rights recently. But what do you think of this question, Nafisa?
I think other jurisdictions or other provinces do have this right for common law individuals, but in this case, what I would suggest is, we can make really strong arguments for a joint family venture. It is a bit more difficult, but if you have a relationship that sort of mirrors a marriage, then it's much easier for us to make those arguments that it should be a regime closer to equalization. So I think it is what it is. The law is a law until it's changed, and unfortunately, it is harder for common law individuals who would like to have a property sharing. It's harder for them for sure.
Any thoughts, Carolyn?
Yeah, so just to add to it, I know like a few years ago they did, explore that possibility of expanding it to the common law element, and it was rejected. I think at the end of the day, it's going to come down to really particular facts and looking at each scenario, the length of the relationship, what type of roles each party played, how they shared expenses, whether or not they shared an account. So it's really going to, at the end of the day, depend on facts. And I think the real clear distinction is to make that, marriage is a legal, outcome. And so they want to make a clear distinction that if you choose to get married, then there's the legal consequences of that. With every division, it's not necessarily that people are expecting that if they're not married, and you're effectively looking at, making a trust claim instead.
I guess the simple answer is if you want the same rights as married couples, get married. If you don't, it's going to be some gray area there, but obviously you got to look into the trust arguments that you're going to be making. Thank you, Carolyn. Let's see what our audience thinks to this cottage question. Are they excluded as an inheritance? Yes, 11%. No, 6%. The wording of the will dictate whether it's excluded. 30%. If it was transferred to one or more siblings, 3%. And it depends, 49%. This is a pretty sophisticated audience we have here today. The correct answer, I guess, is it depends, right? It's going to be a fact-driven exercise. So thank you, everybody, for participating in the poll. How do you protect your inheritance from your spouse? It leads neatly into this question and topic, and I think we're going to turn to Carolyn for this one.
Yeah, thank you. Thank you for that one. So generally, like when you're looking at inheritance, typically if, a will is drafted by a lawyer, by the virtue of the language that they use, an inheritance typically would be protected from family law exclusion if you're separating. However, if you're not careful with what you do with your inheritance, there's a risk that, one person could be required to have to share that with their spouse if they separate or they divorce. So I think it's important to look at the difference of inheritances that were received prior to getting married and make the distinction between inheritances that were received during the marriage. So we can talk about some ways to protect an inheritance that is received during the marriage. So a good thing would be to, if you receive an inheritance during the marriage, would be good to keep a copy of the will. Keep any letters or anything like that you receive from the estate trustee, which basically outlines how much you would be receiving. It's important to open a separate account. You can put that account in your sole name just for the purpose of the inheritance. Also, to keep proof of the amounts that were deposited from the inheritance into the account, and then just keep proof of the balance of the inheritance on the date of marriage. It's important to keep note of that. That might be, as simple as keeping a bank statement. With online banking, that's a lot easier right now, just to show the balances. I always think it's a good idea when I'm preparing marriage contracts is, part of the disclosure. I also tell, my clients that sometimes it's a good idea to just email yourself a copy of these statements. You can always track it, especially if you have an email that has like a large capacity. And then also you want to look at whether or not the will says if there's interest generated from the inheritance, if that's protected. Sometimes people gain, income earned from the inheritance if they're depositing it into an account. It's really important to consider that you do not take your inheritance and, put it into purchasing a matrimonial home or, a cottage or a condo or anything like that you intend to live with your spouse. We don't recommend that, you take that inheritance and you pay down a mortgage. And if you do pay down a mortgage, it would, look into consideration whether or not you're living in that property with your spouse. We don't recommend that you use an inheritance to pay off any joint debt, or that you just, don't deplete your inheritance until after you're married. So if you're going to spend it, spend it after you're married. And I know people like to buy cars and whatnot, but it's always not great to buy a depreciating asset. So in terms of, protecting your inheritance during the marriage, a lot of it does overlap. We still, recommend that you document and keep proof of the inheritance that you received. Again, you open a separate account, keep it in your own sole name, keep proof of the inheritance, how it was deposited into your account. Again, we don't recommend using that inheritance received in the marriage to buy jointly owned assets or anything like that with your spouse. Not recommending to pay off joint debt. Don't recommend, using it to buy a home that you and your spouse will end up living. Assets, again, we don't recommend buying depreciating assets, because the reason we recommend that is we only get to exclude the value that's traceable by the inheritance. So if you go out and buy, a wonderful sports car and it's worth half the value at the date of separation, you're only going to get the exclusion of the value at the date of separation. And it's just really important when we deal with inheritance, and, every time I'm asking my client, like, where's your paperwork? Where's the documents? Where's your evidence? It's always about what you can show and what you can prove. So it's very important to just document. Another way to really do it is, again, we always recommend that if you're coming in with a large inheritance or you're getting it, you can do a marriage contract. Sometimes people forget that people do what we call post-nuptial marriage contracts. So you can do marriage contracts that just deals with an inheritance, after you get married. A lot of the time, you're a parent, loved your spouse, and you're thinking, well, I do want to pay down the mortgage, but if we, separate, I want to have that money protected. So you could do a post-nuptial marriage contract that covers that. If you're not married and you're getting an inheritance, that's where, a cohabitation agreement would come in handy. It would outline, how that would be dealt with in the event of a separation. At the end of the day, it's always good to get legal advice when you receive inheritance.
Great tips. Thank you, Carolyn. Anything you want to add to that, Nafisa?
Yeah, I just want to say, I find a lot of lawyers don't really know this, but when you're looking at a net family property statement and you're trying to say that something is an inheritance, you've got to kind of trace it back to an asset that exists at the date of separation. So I've had some lawyers put in an inheritance, and when I say, okay, well, where is it? They're like, oh, they spent it during the marriage. And it's like, well, then it's not, you can't put that in as an exclusion because it's not there on the date of separation. So that's I think a point that I'd like to kind of bring home in terms of it's got to be in existence at the date of separation.
Yeah, I guess my tip would be, and that's a great tip, would be keep your funds separate, right? Don't put them into a joint account. When you start mixing funds together, and oftentimes people have their paychecks going into that and they're paying household bills, how do you know what part is the inheritance and what part is the other funds? It becomes very difficult to trace those. And you can have multiple traces, right? So Carolyn, if you sell that sports car and buy a motorcycle, that motorcycle will still be part of that traced exclusion. Do you agree with that?
Yeah. And like Nafisa said, it's really follow the money. And that's why we're like always, whenever we have inheritance, it's paper, documentation. And it's, some people keep great records and some people don't. So now you've heard this webinar, you know to keep good records.
And you'll get the estate's lawyer, if they're still practicing, will have the report and probably a copy of the transfer that showing you're receiving the inheritance. The trick is showing us, okay, where did that money go and where is it today, like Nafisa said. Really, really important topic. Thank you for that. All right, let's move into family trusts. So this is often an area, a lot of family lawyers don't get exposure to this, but it can be quite complicated and have fairly significant impact on property sharing. So we gave the difficult one to Nafisa, and Carolyn and I are taking these. No, Carolyn's got crypto coming up, I think. So okay.
Guys, yeah,
So one difficult one for Nafisa, and then we're going to throw a hard ball at Carolyn in a moment. So this one's yours, Nafisa.
Yeah, so family trust is a very complex area. So if we just go back to the basics, under Section 4 of the Family Law Act, that's where property is defined. And what it's defined as is an interest, present or future, vested or contingent in real or personal property. So with this definition, it is a very broad definition. And so an interest in a trust is actually, it is considered property. So once we kind of establish, okay, it is property, what I found helpful is really looking at, okay, what is the timing of the trust? Okay, so when was it established? And that determination will establish whether it's included, excluded, or deducted in equalization. So where there's a trust interest that's established prior to marriage, the value of the interest at the date of marriage is what's deducted, and the value of the interest as of the date of separation is included. Where you have a trust interest that's established during the marriage, the value of the interest is excluded, and that's only assuming that it meets the qualifications of the exclusion in Section 4.2 of the Family Law Act. So, for example, if it's a gift or if it's an inheritance, a part of an inheritance, that's where you could actually exclude it. Where there is a distribution from a trust, where the party's interest is established prior to marriage, the value of the distribution during the marriage will still exist as of the date of separation, and it is included. So I think it's important when you're dealing with a family trust, you really need to get into the details of that trust to understand the timing of it so that you can appropriately deal with it in equalization. When I was reviewing the case law to talk about this section, I found that the courts in Ontario have had very different ways of how they value trust interest, because it is a contingent interest, and it's across the board. It's a very difficult issue. What is the value of that trust? And so I've seen different approaches used by the courts. So there's an if and when approach. So what the courts would do in an if and when is they would look at, okay, if and when the beneficiary receives payment from the trust in the future, that will be considered to be holding that portion in trust for the other spouse, and that's kind of how it's distributed. This can get tricky because you're looking at sort of like you're looking at equalization as of your date of separation, but with an if and when, you're actually dividing at a future date. So that's a bit of a tricky one. Another way that the courts have valued trust is using something called a notional pro rata distribution. So with this approach, what the court will do is they'll take the value of the trust on the valuation date. They'll divide it by the number of beneficiaries, and then they assign a notional equal share of that property within equalization. And then the third approach that I found the courts using is an examination of purpose and history. I think this is, in my opinion, probably the best way to do it. So what the court will do is they'll approach it really factually. They examine the facts of that particular case. So what they will look at is, what was the reason the trust was created? How has it been operating? And then they use this assessment to figure out, okay, what is the appropriate value that we should ascribe to that asset? The reason that I like this approach is because it really makes it factually based. Sometimes, there are individuals that will try to use trusts to trump the other spouse's right to an equalization. This approach allows for a very detailed analysis of the trust, the history of the trust, and how the trust has been utilized in the past in order to figure out how to use it for the purposes of equalization. So that's a little bit of, there's a lot more to know about trusts. And if you have any questions, definitely reach out to me. But it's a very complex area.
Wow. A lot to cover off in a short period of time. You did a fantastic job, Nafisa. I'm going to apologize ahead of time. There's some construction starting outside, so if I mute, you know why. All right, let's go to our next poll question. Does every type of pension require an official valuation? So let's see what our audience thinks of this poll question. And we'll get everybody. Sorry, Carolyn, while we're waiting, did you want to add anything to the trusts?
No, I think you did an excellent job. I think with trust, I do agree with you, Nafisa, that the last approach, looking at the facts, are very particular. I just wanted to add that when we're looking at the facts, also, a lot of the time you'll hear like the other party will say, if you're on the side, trying to include the trust, they'll say, oh, it was for tax planning, or, it's for estate planning for a parent, or that sort of thing. And I think when you're taking the value approach, like looking at the facts, it does make it easier to approach it, to include it for the net family property that way.
All right, let's see what our audience thinks of this question. All right, so do we need an official valuation? Yes, 29%, no, 26%. It depends on whether it's a defined contribution pension, 26%. Yes, if a survivor's benefit is portions included, 1%, all of the above. So fairly well spread out answers. What's the correct answer of this one?
It's funny that it could someone all the above, because then it's yes and no. So I guess I think the answer is no. You don't necessarily require an official valuation for pensions, and I think I have the next topic, so I can actually explain that a little bit more.
Yeah, take it away.
So when I have clients that have pensions, one of the first questions that I always ask is it a defined benefit or a defined contribution pension? Because the answer to this question will allow me to determine what will my next steps be with regards to valuing that pension for the purposes of equalization. So in terms of the difference, a defined benefit pension plan provides for a specified payment upon retirement. So a defined benefit plan, it provides eligible employees guaranteed income for life when they retire. And so in this case, the employers guarantee a specific retirement benefit amount for each participant. And it's based on factors such as the employer's salary and years of service. So when you have a defined benefit plan, that is when we need to obtain a family law value for the purposes of equalization. So when we have a defined benefit plan, we fill out the pension forms. These are submitted to the plan administrator, who then provides us with a family law value for that pension. Once you have that family law value, that is the number that you're plugging into your financial statement, and that's the value of the pension. So one thing that I want to just remind everyone, always when you're putting in your values for your pensions, always deduct a notional disposition tax for them. And sometimes you forget to do that, but it's important because the value of that pension needs to be deducted for notional disposition taxes. And I will explain that in a next portion of this presentation, but it is important to really flag that right now. In terms of a defined contribution pension, so this is a plan that allows employees and employers, if they choose, to contribute and invest in funds over time to save for retirement. So that's a different type of contribution plan. And for a defined contribution plan, you can simply obtain a statement that provides for the value of that pension on the date of separation. So for example, a 401k pension is a defined contribution plan, and a statement would provide for a value. When I deal with pensions, the second question that I ask is whether that pension is in pay or not. And the reason that I ask this question is because when a pension is in pay, and you get a family law value, if it's a defined benefit pension, there will be a survivor benefit that's attributed to that pension. And that survivor benefit is actually included in your spouse's side of the ledger for a net family property statement. So you'll get, when a pension's in pay, it's a different pension form that you fill out, but you will get a number that says, this is the pensioner's amount, and this is the survivor benefit. So that survivor benefit needs to go into your net family property statement on the other side of the ledger for your spouse. Both of those assets need to be deducted for notional disposition taxes, but make sure to include the survivor benefit for the other side, because that could be a huge error if you're not doing that. Also, the other reason I ask for whether a pension's in pay is because there are certain rules that disallow you from a lump sum transfer of a pension upon when you're figuring out equalization. So when a pension's in pay, you cannot provide a lump sum transfer of that pension to satisfy an equalization payment. The only way that you can satisfy that is from monthly deductions of that pension in pay. So those are important questions that I ask. And again, pensions are a very difficult area of law, especially when we have pensions that are not pursuant to the Pension Benefit Act, but that actually are federal pensions, because then you actually need an actuary to assist you in obtaining what number do we put in for the family law value of the pension. So it can get complicated in that situation as well.
So a survivor's benefit is when somebody elects a portion to go into their spouse's name. But a question came in, how does someone pay for it or share it if they don't have the money in hand?
So if they don't have money in hand, they could actually transfer it from other assets. So we would have to look at sort of the financial statement to see, are there retirement assets that would have to be, it would have to be grossed up, for example. Are there assets from a matrimonial home that's going to be selling? Are there any other investment properties available? But I had a client who had a pension in pay and didn't have enough assets to satisfy the equalization payment. So we actually had to do a division of the pension interest by way of monthly payments. And that's how we did it. But you've got to look at all of the assets, all of the sort of look at the overall picture to see how do you satisfy that equalization payment.
Those are tough cases, and they can sometimes result in seemingly unfair situations. But let's get into crypto. This one's yours, Carolyn.
Thank you. So cryptocurrency, I thought this was a fun one. So thank you for giving this one to me. I think the big thing with cryptocurrency is that there's a lot of question and really important to figure out, is there cryptocurrency at all? Does it even exist? The whole way how, cryptocurrency is either you get it or you don't really get it. It can be a bit overwhelming for lay people who are not involved in it to really understand how it works. And then because cryptocurrency, a lot of the time it's discrete. Sometimes people think that you can hide, your assets in cryptocurrency. So the important thing to realize about cryptocurrency going through, divorce separation is that it is an asset. It does have to be included on your financial statement. It does have to be disclosed. And it does have to be accounted for, and disclosure does have to be provided. Like I said, there is a huge issue with people understanding about how it works. And, sometimes that does even include the family lawyers on how it does work. So you hear what about what is cryptocurrency? You hear language about, a coin or a token. The easiest way to think of it is like it's a database. that records the number of transfers from one user to another. And so when you have the database that records it, that's called the blockchain. And then there's a certain number that's assigned to the coin or the token, and that itself is called a public key. And so what the blockchain does is it records every transaction of a cryptocurrency that the unit has ever made, and that is publicly accessible, like with anyone who has internet connection. Because cryptocurrency is not like tied to any government or third-party bank or anything like that, the transfers they don't have any regulation. And then there's no true like regulating of the transactions. But when it does have the verifying process, that's known as mining. So you can earn like cryptocurrency from mining the blockchain, or you can purchase it on an exchange that sells the currency or from another owner. You can also get it as a gift. So the thing with going through, separation or divorce with cryptocurrency is, is the best honesty, is the best policy. Both of parties are under an obligation to provide, full, frank disclosure of all their assets. And that's why we always recommend that it's important to be honest in that process. The thing is that sometimes people think, someone is being dishonest about disclosing assets. There's times where, the court can order a full investigation. We call that like a forensic investigation. The issue with that is that it can be very costly. And let's face it, like if people do have cryptocurrency, you have people that maybe dabble a little bit. They buy like hundreds or, small, maybe $1,000 of, cryptocurrency, or they not necessarily like buy millions of dollars of assets. So you have to look at like the cost benefit analysis of doing that investigation. At the end of the day, yeah, it's possible that, the spouse could try and hide cryptocurrency, but you have to remember that there should be like a chain of money. It's the same idea where you sort of trace the money. You would see if someone's involved in crypto, you probably hear them talking about it. You hear them like the good thing is that people who like crypto are very enthusiastic about it. They do talk about it a lot. The only thing is like you hear the cryptocurrency markets themselves, they are anonymous, they are, private, and it is, quite frankly, it's impossible to track. But people always think that, but that's not always the case. So there's popular ones that you hear like Bitcoin or Ethereum. Those ones are fully transparent because they do have, special forensics that can do that. So the problem with tracking cryptocurrency, why it's so problematic, is that you need to have a private key. And so the private key is the password that's held by the owner of the cryptocurrency that allows them to spend or trade coins. The problem with this is the private key is not necessarily held in one particular way. So it could be, if it's not known or lost, then there's no way, it's impossible to access the cryptocurrency. So the key is kept in what is called like a virtual wallet, and that virtual wallet could be anything you want it to be. It could be, just writing it down on a piece of paper. It could be an app or some other software that, holds the numbers. Some people use hardware, like, I don't know, people use these, but like a USB key or a drive, something that's not necessarily connected to the internet. So in order to make full disclosure about your cryptocurrency, the party that has it would have to provide documentation information about their private keys, because once the private keys are known, it's possible to track all that information, because the blockchain would log every single detail and transaction. So the worries about is figuring out whether or not your spouse has the cryptocurrency. They probably would have talked about it a lot, and then the reality is that crypto is very volatile, so it's quite possible that they may have made bad decisions or invested in the cryptocurrency at the most time. So in terms of getting full disclosure from your spouse for the cryptocurrency of the assets, again, it would be providing the public keychain, and from there they would be able to provide like a summary of all the transactions through their blockchain. That would be sufficient to get that information. If they use like an owner exchange, it's also possible to try and get a court order for some disclosure for some information. Like people do think that, even those like impossible to track, there is some cooperation from certain, like the major cryptocurrencies like Bitcoin or Ethereum to actually have them disclose that information. But the key again is that you need to have that public key. One thing to mention, because of cryptocurrency is so volatile, it can shift when you're determining your net family property, because typically under family law, we look at the value as at the date of separation, but in recognition of the volatility of it, sometimes the lawyers, we will say that we would come back to the value and divide the cryptocurrency as at the value of when they are, the current day value, opposed to the value at the date of separation, because that way both parties are sort of sharing in the volatility of it. So we do always recommend that maybe you would come back to like holding off on a final settlement of that piece until you can look at the current day value. Transferring it can be another thing. Some people, they would want to have that cryptocurrency, like, just give over that public key. Some people want to be, bought out financially, like with a monetary payment for it. It really would just have to depends on the facts of the particular, situation, whatever situation would make sense.
Wow, great job. My tips would be mindful of the data separation because it is so volatile. Make your disclosure requests include whether or not they own any cryptocurrency or any other type of digital asset, including an NFT, and get a sworn financial statement. So if it shows up later, you can go back and make your claim. So let's speed up a little bit. I'm mindful of our time and we want to save some time for Q&A. So 2-3 minutes, Nafisa, tax and other considerations?
Yeah, sure. So in terms of tax and other considerations, when we talk about notional disposition taxes, it's just a really fancy way of saying financial consequences for cashing in an asset. So that could include a pension, an RSP, commissions for real estate agents, taxes owing on the sale of investment property or stocks. So when you're filling out your financial statements, just make sure that you're including all notional disposition taxes. So for example, if your client has an RSP and in there's $100,000, you would include $100,000 in the asset portion of the financial statement. And then when you go to debt, you would put in a line for notional disposition tax or an amount. The reason why is that RSP is not really worth that amount because it will be deducted for taxes when it's used up. So usually I see between 15 to 25%. I would recommend if it's a very large asset, to obtain an actual evaluator to provide a very exact percentage for what amount you use for your notional disposition tax on assets, because it's the rate, the tax rate at the time that the asset is disposed of, and that could create a huge fluctuation if you're using 15% and it should actually be 25%, for example. So just be careful with that. Another disposition is capital gains. So a capital gain is the difference between a purchase price and a sale price. And usually when you're putting that into your financial statement, it's 50% of that amount. So you'll need to know what the purchase price of that asset is in determining what amount to put in your client's financial statement. Investment properties is another one. So if you have a home and an investment property, you sell that investment property, you're going to have to pay capital gains on that investment property. So you would want to include a contingent tax for that in your financial statement. Stocks, bonds, shares of mutual funds, those are all subject to notional disposition taxes. And so don't forget to include these in your financial statements. The other thing that I see quite often is people forget to include notional disposition taxes for date of marriage assets. So if you have a date of marriage RSP and you have that as an asset on your date of marriage, make sure that you have a corresponding liability for notional disposition tax of that RSP, because there is one on the date of marriage as well.
Great stuff. Thank you. Let's run our poll. Final poll today. We had some questions coming in on crypto. Basically, what do you if they're going to hide the asset, how do you find it? It's no different than any other asset people are hiding during a separation or divorce, whether it's cash or something else. If you get a sworn financial statement and they say doesn't exist, and you find out that it does, then obviously that they've misled the court and executed a false financial statement. That'd be a basis to set aside any agreement that you do make. So when would a business valuation be required? We give everybody a chance to answer this question, and I think let's move in. Well, let's see. We've got always, never, it depends. Let's see. So always 38%, never 1. It depends on what type of business. Only if it's incorporated, if there are any, or if there are multiple shareholders. So it looks like it depends. It seems to be the common answer in today's presentation. Thank you everybody for sending in your answers. So let's go to the next slide. We've got business valuations as a live event, part 1 and 2. So when you're thinking of business valuations, these are some of the issues you want to be mindful of. So when I was preparing for today's presentation, basically there's 3 questions you want to ask yourself. First of all, do I need a business valuation in this particular case or for this family? I've had cases where one spouse was in the trade, they had a van full of tools and that was it, no inventory. We agreed to the business valuation for that particular company, which was a bad choice because the valuation cost more than the actual business was worth. It was a truck full of used tools. So ask that question, do I need one? Next is, what process do I want to get in? If you're in the collaborative process, perhaps you can do it jointly and take a verbal report as opposed to a written report. If you're in litigation, are you going to require a written report at the end of the case to use at trial if there's a dispute over the value of the business? So think about what process you're in. And the third question I would ask you to consider is, think about what type of report do you need? Perhaps just a high-level overview indicating this is what this particular business is worth, and the expert would say it's not worth going any further than that. Maybe an oral report would do, or you're going to need a written report with some forensics behind it. So lots to consider. If you want to learn more, go to Business Valuations 101 and 201, the advanced topic for this subject matter. It's going to be in the show notes. Let's go to unequal division of property, 2 minutes or less. And I'm going to give it back to Carolyn. We're really giving you the hardball here.
Yeah, this one is a fun one. So important to recognize, like when typically the law is that you should do an equal division to equalize the parties' family property. But there are some considerations where legal system says that an equal division of net family property would be unfair because of the circumstances. So the language that they use isn't, I said unfair, but it's really not really unfair. The test is extremely high. There's a very high threshold. The language that the court uses is unconscionable, and so you still struggle with what does that mean, and it really is going to be driven by the facts. So once this few circumstances that would call to looking at whether there should be an unequal division would be if one spouse neglects to tell the other person about significant debt that they had on the date of marriage or other liabilities. Another one would be examples where one spouse incurs debt recklessly or if they do it in bad faith. Another one could be if one spouse intentionally recklessly depletes his or her net family property. If the parties have some form of written agreement between them that outlines when it would be appropriate way to have an unequal division. And so it's very, I wanted to share a couple examples out of cases to show court has ordered for an unequal division. And one example, there was, a family, a husband and wife, they were having issues in the relationship. The wife was let's just say like $180,000. Husband, they had a home equity line of credit. Husband pressured her to use her inheritance to pay down that home equity line of credit. She did so, and then 2-3 months later after that, they separated. So in that example, the court found it was unreasonable, and they ordered that there would be an unequal division to her advantage to reflect the credit. Another example was a circumstance where a wife had incurred a line of credit, like it was in place and she was using it. Husband didn't know. She found after they close to the separation that she was just buying things, for the purpose buying things that not that she needed it. So they had found that it would be appropriate for an unequal division in husband's favor for the difference of that line of credit.
All right, and short marriages as well. Let's get into supersized CP teams. I apologize for my ambient noise here. So all I want to say about this is when you're doing collaborative practice and you're sharing property, you have a complicated business structure or tax issues, it's always good to consider expanding your team. Most of the teams I work with have a family professional and a financial professional. We thought we had an agreement in this one particular case where we'd covered off all the issues. We brought in some experts. So we brought a corporate lawyer in, we brought an estates lawyer in, and we brought a tax planning lawyer in. And we just did an issue identification when we're coming up with our final agreement. It turned out there's about 10 or 12 issues that the family law lawyers overlooked that would have affected the enforceability and the effectiveness of the agreement we're putting together. So if you're helping family businesses or families with a lot of wealth, you may want to consider bringing some experts in, especially if you're doing it collaboratively, to make sure that you cover all the issues off to make sure that you get a good agreement for your clients. So thank you for that, Carolyn and Nafisa. Maybe we'll have some time for Q&A. We'll bring our host back in. Shannon, are you back?
I am. Thank you, Russell, Nafisa, and Carolyn. We hope everyone found that presentation insightful. Just want to thank everyone for sending in your questions. We've had an overwhelming amount of questions come in. We've had a really great turnout today, so we're going to do our best to get through as many as we can right now. In the next few minutes, we just want to be mindful of everyone's time. And just a quick reminder that there will be a survey that pops up in your browser following the webinar that will ask for your feedback. So please, if you have the time, we welcome and appreciate any feedback that you have, as it helps us to grow. And we will be, as a sign of our appreciation, we'll be providing those who answer the survey with a complimentary advanced copy of our ebook on Divorce and Property Sharing 101. So getting into Q&A, thank you again, everyone who sent in their questions. A question that I have here from the audience is a family trust treated the same as an inheritance?
Nafisa, what do you think?
So again, no, I don't think so. I think it really depends on timing again, right? So again, I kind of spoke about that quite a bit in terms of timeline. So when was the trust established? If it was established as a way during the marriage, and it qualifies as a Section 4.2 exclusion, it would be an inheritance excluded. So I think timing is important. If it was provided prior to the marriage, then it could be a deduction.
Thank you, Nafisa. Another question that we have here is, who gets the increase in value of a non-matrimonial house? Is it split, or does it go to the person who pays the mortgage?
Carolyn, what do you think?
You kind of need a little bit more context. So I think typically you'd have to look at, whether or not it's a matrimonial home on the date of marriage, if you're still living there on the date of separation, and look at it. Because I think when we're talking about the matrimonial home, just important to remember that if you had the matrimonial home on the date of marriage and then you continue to live on it, then you wouldn't get that date of marriage deduction if that were the case. So I think it depends.
It depends. It seems to be a common answer today.
Great. Well, that is all the time we have for Q&A today. I do just want to mention that we do keep all of your questions on hand as well, and take them into consideration for future presentations as we create the content. So just want to thank everyone for sending those in, and just want to thank our panel once again for joining us, and everyone in the audience today. We hope you found it helpful. And as I mentioned at the beginning of the presentation, keep an eye out for a follow-up email that we'll be sending tomorrow with additional resources. And if you have any questions about our virtual event series or any general comments for our team, please feel free to reach out to me at shannon@russellalexander.com. And we host our virtual event series bi-weekly for anyone new that's joining us. So our next presentation will be on Wednesday, August 24th, and that will be on divorced and separated parents, back to school tips, tricks, and common disputes. And I'll be including the information on registration in that email tomorrow as well. We just want to thank everyone again, and we hope you have a great day. Thanks for joining us.
Great job, Shannon. Thank you, Nafisa. Thank you, Carolyn. Back to school. It's always a busy time of year for family lawyers. That'll be a good one.
Thanks again, everyone.
Yeah. Take care.